Good morning. Are you Tiffany English?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. English, in 18-30705, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the offense of assault on a peace officer, a second-degree felony, and that was a 7-year deferred probation. Is that correct?
Yes, ma'am.
And in cause number 19-31722, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
Hey, Judge, I just want to clarify for the court's knowledge. I spoke with Ms. Cole. That was extended. When I first looked at it, it looked like it was
Okay.
2019, and now it's 25, that it would have been expired, but I confirmed
That it had.
been expired.
Okay, thank you. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you tested positive on a drug patch for tetrahydrocannabinol and cocaine May 8th of 2025. And is that true or not true?
Yes, ma'am.
True or
Yeah,
not?
sure.
Count 2 in each case alleges that you failed to provide verification of completing a job search. And is that true or not true?
Yes, true.
Count 3 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
True.
Count 4 in each case alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. English is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. In cause number 18-30705, find sufficient evidence to find you guilty, and at this time, find you guilty of assault on a peace officer. Sentence you in accordance with your plea agreement to a term of 3 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
In cause number 19-31722, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
These 2 cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition.
Yes, ma'am.
Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess.
This moment is a major turning point in Tiffany English's hearing. By entering pleas of true to the alleged probation violations, she is acknowledging the state's claims that she violated the terms of her probation. The judge is now focused not on proving the original allegations again, but on deciding the consequences of those violations and whether the plea agreement should be accepted. The admitted violations include positive drug tests, failure to provide job search verification, unpaid court fees, and failure to complete a required program. With multiple violations before the court, the next decision carries serious weight. Do you think the judge's approach to probation violations should focus more on punishment or rehabilitation? Let's return to the courtroom as the judge delivers the final decision.
You've gone over that with them, and as notice either has or will be filed of
Notice
those?
will be filed. We'll give oral notice on the record today that we will file notice of his intent to enhance his punishment based on his prior convictions. we'll get that in writing and get that filed this week.
And there's at least 2 prior non-state jail sequenced.
Non-state jails.
Okay. So, Mr. Scott, if those prior convictions are true, what that means is that if you go to trial and you're found guilty, the range of punishment becomes that of a habitual offender, which is a minimum 25 years in prison up to 99 years or life. Do you understand?
Yes, ma'am.
I have here on the computer a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to go, I guess, on count 1 only, and for a 15-year term in the institutional division of the Texas Department of Corrections. That would be to go on the robbery itself without those enhancements for a 15-year sentence. You have every right to reject that and have your case set for trial. I want to make sure you understand what your possible consequences are and what your options are. You understand all of that.
I understand the court.
And you want to reject that offer and have your case set for trial.
Yes, ma'am.
All right, we'll get that done. Mr. Scott, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, Mr. Rojas, you are released. Mr. Scott, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Good morning, sir. Are you Terry Thompson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Thompson, in cause number 250474, you're charged with a third-degree felony offense of false statement regarding property or credit, and that's from March 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, sir.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, sir.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thompson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of making a false statement regarding property or credit, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I didn't go over this as well. Are you a U.S. citizen?
Yes, ma'am.
Okay. I'm required to ask. So I will also sign a dismissal as part of this plea agreement in cause number 250475. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir.
Thank you, ma'am. Thank you, Judge.
Thank you, sir.
Today's courtroom proceedings showed 3 very different outcomes. Tiffany English's probation was revoked after she admitted multiple violations, resulting in prison sentences in 2 separate felony cases that will run concurrently. Carrington Scott rejected a plea agreement and chose to move forward toward trial, facing the possibility of a much higher punishment range if prior convictions are proven. Terry Thompson accepted a plea agreement, pleaded guilty, and received a 3-year prison sentence, while another related case was dismissed as part of the agreement. These hearings highlight how critical every decision can be inside a courtroom, from accepting responsibility to choosing whether to proceed to trial. The judge's rulings demonstrate how plea agreements, probation conditions, and prior records can significantly impact a defendant's future.